How many times you turn to a judge and say, Your Honor, if we just let you, I know the guidelines are this. If you put this guy in jail for this long, the family's going to lose their house. And they've got 4 young kids.
He should have thought of that before.
And the judge literally says, Mr. Inch, your client didn't think about that when he did this or she did this. I can't think about that now whenever I do this.
And so what's happening is 2 things. One, you're making the same appeal that every other lawyer has made, and that prosecutor and that judge have insulated themselves so rigorously.
Those are their system ones. Yeah, those are their defense mechanisms. Yep.
Because they have to.
They have to.
If they're not a bad person, they have to do that because they hear the same argument 99 times out of 100. They've got to respond the same way or they'll go bonkers.
Right. And you're using something that's outside of what they're supposed to consider, and so therefore they're going to then go back to the letter of the law in order to find themselves not that this isn't their problem. I'm not responsible for this.
It's a place of comfort, and and they go to seminars too, and they go sit in the back with their colleagues, and they talk about what prosecutors deal with, and judges talk to other judges about what they deal with, and many of the judges were former prosecutors, and you get that, and so they are insulating themselves that way. Yeah. But when you come into the courtroom and you are presenting a different perspective that they haven't heard 5 days out of that 5-day week.
And on top of that, the client has done things that are now meaningful based off of the information we're saying. Judge, we understand that this was a terrible event, and we want to turn and apologize to the victims and really let them know this is not something that we wished was going to happen. Your Honor, we know that there's going to be consequences to this. Are there some things about my client that I could share with you that I find to be very important? If you'd give me a chance, I'd love to share those with you, right? And then you wait for the responses, and you say, because so many, like even just the other day, I was doing a sentencing in Richmond. The judge was looking at a computer screen the whole time the client was doing allocution, and I even tried to interrupt and say, "Could you turn to the judge? It's the judge that it's the judge that needs to hear this. If you could turn, just trying to get the judge's attention." No, the judge ended up giving him what we wanted, which was the baseline 2 years mandatory minimum. There, I think the guidelines were asking for 3.5 years. But it was frustrating, and at the same point in time, the client was already convinced that the judge didn't have any interest in hearing his story. And we had done everything to prep him to talk about the things and to bypass and try to overlook the things that were bad on his criminal record. I think he'd been convicted of a rape charge in like the mid-90s or early 90s. But he's now 60 years old, and he happened to have a gun in a car when there was a traffic stop, right? And so violent felon in possession of a firearm for something that was like 30 years old. And even the victim of that bad conviction showed up in the gallery to support him because it was like his long ago ex-wife. Oh wow! And so even having that, but the fact that the judge didn't look at him was hugely impactful to the client. The client was in tears. He's just like, this judge doesn't listen to anybody. And then we're sitting there saying we want to make an emotional appeal to the judge for the things that we think the judge ought to hear, and now the client doesn't feel heard.
Yeah, and that's a huge thing, because one of the things that you have to have as a skill as an attorney who goes into especially a criminal courtroom is you have a judge who's going to hear 10 or 15 cases that day, and you do have to have some ability to take that record player. I know nobody knows what a record player is anymore, but it's spinning and spinning.
Turntable.
Spinning. Right. But the DJs may know. But you need to scratch the needle and say, look, I'm here. You're going to listen to my client.
So what you're talking about is a pattern interrupt.
Yes.
That's what, so in our terms, that's a pattern interrupt. So the judges and the prosecutors all get into all these patterns because they're used to doing it day in and day out.
Because it's the only way you can make sense of a job that you do 5 days a week for 365 days a year for 10 years.
And so it's all the same thing. The clients, they are in patterns as well. They're in system one thought processes and patterns. So anytime anyone's in a pattern or does something that you don't like how that pattern ends, you do a pattern interrupt, Like when you're talking to the client, make sure you have your cell phone somewhere so that especially if you know it's a difficult client, then there's all these different things that you can do that can be pattern interrupts for the clients. They come in and they go into that same diatribe that they always do. Have your cell phone nearby. You always have your cell phone nearby and drop it. Like, oh my God, wait a second, I need to drop my cell phone. Right. And you interrupt the pattern. That's the first stage, is get them out of the system one thought process so you can get them extracted from the pattern. And then now each time I get them pulled from the pattern, now I can try to shade them towards a different system too that they're not in.
Because that's when you're really listening, that's when you're really learning, and that's when you're really hearing people.
Right. Yeah. And then so the long and short of this is when you get the client to recognize, take responsibility, and see, because that's the other thing is when they're in defensive posture, they can't do that because they can't. It's not that they can't take responsibility. They understand that there's so many other things that led to this